Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host. Hello. Another wonderful Saturday is with us. In fact, it's the last Saturday of the month of October 2025. And we are live on The Community and the Law, live on BWTV, bringing you a discussion that will get you on the right-hand side of the law. Judicial review for UK visa refusal, the law, the process, and implications. We'll be delving into this, so I invite you to tell the other person that we are live. It is The Community and the Law. My name is Oreku Frimpong. Welcome on board.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, I mentioned that we are live again the very last Saturday of the month of October 2025. It's been pink, it's been Black History Month. We stand in tall in pride and power. And of course, we are educating ourselves and reinforcing knowledge in all the legal matters that pertain to our life here in the UK. Good evening. My name is Ulrich Frimpon, and welcome to another edition of the community and the law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, and they deal with all matters legal when it comes to your immigration application, your issues of family and law, your issues of property, business development and advice, and of course, your understanding of all the updates that will come from the Home Office. We are this afternoon once again going to have a discussion, and we'll be live at BWF Solicitors both on Facebook and YouTube, and at BWTV UK both on Facebook and YouTube. And we're looking at judicial review for a UK visa refusal. We're looking at the law, the process, and the implications for whatever it is that would apply to you. Our very friend and own lawyer from BWF Solicitors, Lawyer Charles Asma, will be our guest and resource person this afternoon. So keep your fingers crossed, tell the other person to log on, like the page, share, and also invite other people to come join us so we all share knowledge and experiences together. So I know you're ready, and as I am also very ready, I want to say this is brought to you once again by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. Thank you, BWF Solicitors, for always being there and supporting us to bring the community and the law. And this afternoon, as I said, we're looking at judicial review and we shall be dissecting that. Why do you go for a judicial review? What are the processes involved? What documents we need to present to the Home Office? And I asked myself the question, why is it that I would want to speak to the Home Office first before I go to the law enforcement agencies? I go to a lawyer, I go to the judges, and all that. We're looking at the law behind that. We're looking at the processes behind that. and we're looking at what implications they have for us. But in the meantime, I know those of you who have joined us will want to have that special welcome, and I want to do that. Hello, Tilly. Thank you very much. And you are welcoming everybody, saying hello, lovely family. Tilly is calling on other people to come join. And I think I'll add my voice to that. And I do my senior minister. Come, the class is ongoing. Let's join together to do this. Nanechi Ahne, you're being called. Your name is mentioned. We have Ezekiel Johnson. Yes, a long time since we heard from you. Kofinat, back in Maya. Where are you? Come join us. Yes, I know you'll be here. Taribu Ade says good afternoon to everyone that has joined us. Welcome on board. We have Margareta Dumens being called by Tilly. Fred Amoa. Tilly, you have all the names on you. Thank you very much. And please share the program when you join. That's one from Ade Taribu as well. I think those two need to be given an award at the end of the year 2025. Please kindly share, comment, and like. Thank you very much. Tilly Duma, I'm watching you live from Bromley Road. Well, and Najma has responded. That's the spirit of the whole thing. So yes, let's join as a community and share, because others need to benefit from it as well. Well, let's start off with this. We've got some appreciations expressed by people who have benefited from the services of BWF solicitors. And I will be also sharing with you a client success video that tells you what it is that people have achieved from using the services of BWF solicitors. So Israel is the first one I'm doing here. Israel says, thank you so much, BWF, for your help, honesty, professionalism, and integrity. This is the second time that you have come to my intervention. Thank you, Senior Lawyer Benadosu. Well done, Emmanuel. Keep up the good work. I feel so proud to be associated with BWF solicitors, and I believe that people's testimonies and all the other feedback pieces that they give tell the story that when you get to BWF solicitors, there is something real good in there, and you have almost 100% success rate when you go there. And I keep saying, there's only law firm here in the UK that gives you the Ghanaian chocolate and the Ghanaian welcome. So visit them on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340, 0208 493 7340. Now, having said what Israel has put out, let's see this video about client success as we have.
Ex-skilled worker dependent switched to 5-year partner route with a new British partner. The skilled worker's ex-partner successfully applied to switch to a new spouse visa as the spouse of a British citizen. Case overview. Our client came to the UK in 2023 with her husband, who was a sponsored skilled worker. Unfortunately, their marriage broke down because she met a new partner. The challenge: divorcing and marrying within a short time. Our client had received a letter from the Home Office stating that her ex-husband had reported that they were separated. She was given 60 days to switch her visa or leave the UK. She was advised that, as they were married in Ghana, she could file for divorce in Ghana. She followed our advice and obtained a court divorce from Ghana. She subsequently entered into a customary marriage in Ghana. Proxies represented her and her new husband. Once the marriage was registered in Ghana, she was ready to make her application without leaving the UK. Our strategy. As a result of the visa cancellation, our client needed to act quickly. We advised her about the lawful way to obtain an overseas divorce under the Family Law Act. Additionally, we ensured that the subsequent marriage complied with the stringent UK laws regarding the validity and genuineness of the relationship. With our vast experience in family and Ghanaian law, we ensured that she had the best chance of success. The outcome: spousal visa, granted within priority processing. The spouse visa was granted within priority processing timeframes, enabling the new couple to move forward with the marriage. This case illustrates how speed and knowledge of family and Ghanaian laws can be effectively leveraged in time-sensitive cases, particularly for dependents facing visa cancellation. Facing complex immigration issues? Contact BWF solicitors today.
Right, thank you very much, BWF solicitors. Um, they handle complex situations, and I believe that no matter how it is, explain your situation to them, and they will help you. I've said you can contact them. They are on the fourth floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters in North. Call them 0208 493 7340. Or if you are in Ghana and you want to access their services, their office number is 055 589 5959, 055 589 5959. And in any emergency situation, you can call 004477 127 61884, 004477 127 61884. Visit their website, bwfsolicitors.com, or all the social media platforms at BWF Solicitors. Well, that done and that out of the way, we want to also encourage everyone that has had a chance of tasting the services of BWF Solicitors to give us the review. Go to Google and find BWF Solicitors and leave your comment and feedback there, or you can visit the various social media platforms, DMS, and we will bring it for people to also know that, yes, BWF Solicitors has the right services for everyone. Remember, the number is 0208 493 7340, 0208 493 7340. Thank you very much, BWF Solicitors, and thank you for also helping us come on TV every Saturday afternoon as we bring the community and the law. It happens on TV, YouTube, Facebook every Saturday between 4 and 6 p.m. UK time. Well, let's look at some updates that we have this week highlighted. And it's about the proposed and anticipated changes to the indefinite leave to remain applications and situations here in the UK. First of all, I have this video. Let's watch this.
Home Office announces contribution-based settlement model. The Home Secretary has provided an update on the proposals to change the requirements for settlement, indefinite leave to remain. It has been announced that a contribution-based settlement model will be introduced. Under the proposal, the qualifying period for settlement, indefinite leave to remain, will increase from 5 years to 10 years of lawful residence in the UK. The model will allow applicants to shorten these 10 years if they meet specific earnings or integration criteria. To qualify, applicants will need to demonstrate 1. Being in employment and having made a minimum national insurance contribution. 2. Not having claimed benefits. 3. Meet a high standard of English language proficiency. 4. Maintained a clean criminal record. 5. Provide evidence of giving back, such as volunteering in the local community. For more information, please visit our social media platforms.
Yes, as we said, you can contact BWF Solicitors in situations like this. If you want further understanding and insight into the situation, when it's going to happen, when it does happen, what will happen, and what you need to know and do, please contact BWF Solicitors on 0208 493 7340, or in Ghana 055 589 5959. BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. By public transport, you get on the Victoria line to Seven Sisters. Use exit number 2 from the train station, and that brings you to the frontage of the Anna House. Climb up to the fourth floor, find BWF Solicitors. Well, another bit of update is, let me give you the nugget first. Yes, the nugget is that piece of information we drop on our social media platforms every Monday. And we aim to get you to understand and appreciate certain situations and also to be able to get into that or around it, so you are able to have informed uh, experiences and make informed decisions as well. We're talking about assessment of good character for British nationality, and that including entering the UK illegally. Since February 2025, for the 10th of February 2025, any history of illegal entry into the UK will typically result in refusal, although exceptions may be considered in certain exceptional circumstances. But in all cases, the Secretary of State has a mandatory and discretionary duty to consider individual mitigating and exceptional circumstances in making a decision. Well, we have looked at the case of RL9 versus the Secretary of State for Home Department, a case in 2019. It was the England and Wales Court of Appeal case, CIV 2024, and it talked about good character. And we have found out that it includes entering the UK illegally. So you may say, well, I came around 20 years ago. I've lived for a very long time. I've spent my 20 years and all the rest of it. But if you're going for your nationality, where you register for citizenship and all the rest of it, they look at good character. Now, this good character, this case, as I mentioned, and you will find it on your screen, says includes illegal entry. And I mentioned, and I know Lawyer Asma will be throwing more light on it a little later. And it says that since the 10th of February this year, if you have a history of illegal entry into the UK, it will typically result in refusal, although exceptions may be considered in exceptional circumstances. And the case brought out that in all cases, the Secretary of State has mandatory and discretionary duty to consider individual mitigating and exceptional circumstances in making a decision. So keep that in mind. It's something for your pockets as well. And if you approach any person helping you with your naturalization, registration, and all that, you may have to disclose that so they know what to do about it. So yes, that's our nugget for the week. And based on that, we will be giving you a scenario and see if I can test your knowledge and understanding of that and how you can bring it out. So let's see what Obimpe situation is. Obimpe had traveled to the UK at the back of a lorry in 2010. In 2013, he applied for and was granted limited leave to remain as a parent relying on his child, who is a British citizen. He has since had 3 more British children. In 2023, he was granted indefinite leave to remain. Then in 2025, he consulted you, say you are a qualified person to give advice. Remember last week we were talking about those who are allowed to do that when OISC accreditation and all the rest of it. So let's say you are one of them. So in 2025, Brema Obimpe consulted you to apply for British citizenship for him. He said he heard that because he entered the UK illegally, his application would be refused under the good conduct requirement. So then I test you and ask you, what advice would you give him? Would you say to him, yes, Brema Obimpe, apply because you have indefinite leave to remain, which means that you have been forgiven? Would you say that, no, Obimpe, do not apply as you entered the UK illegally? Or you can tell him, yes, apply. However, you must make a representation providing reasons why your case is exceptional and raise mitigating circumstances. So I've outlined the 3 options as follows. He should not apply as he entered the UK illegally. He can apply because he has indefinite leave to remain, which means he has been forgiven. Or he can apply, however, He must make a representation providing reasons why his case is exceptional and raise mitigating circumstances. Hmm, is it one? Is it two? Could it be three? Let me know, and I'll come back to this at the tail end of the program. But in the meantime, I know and we have reports that some organizations that have a certificate of sponsorship are reporting certain individuals who may have contracts kind of not valid at the moment. I reported them to the Home Office. What are the implications of this and what are the consequences? Watch this.
Home Office announces contribution.
Hello, this is a short video for people who are here as skilled workers and skilled workers dependent. We have identified worrying trends in the community over several months. On average, I receive about 100 calls, and about 70% of those calls relates to this problem that I'm going to talk about. The problem that I've identified is that migrant workers' sponsors are reporting them to the Home Office for their visas to be cancelled. And it could be for so many reasons, but what I've identified is that most of these sponsors are reporting you, the migrants, because they haven't done their jobs properly. As you all know, when somebody sponsors you or a migrant to the UK, there are 5 duties. The most significant ones are the reporting duty, the record-keeping duty, making sure they're compliant with the immigration rules and the UK laws, making sure that they have integrity and they are above complaint. Unfortunately, for some of these sponsored workers, the sponsors have had arrangements in place to support you. And of course, they are aware that you are not turning up to work, which clearly is against the immigration rules. So what they're doing now is that because the Home Office is aware of this problem, that some workers are in the UK and they haven't even reported to their sponsors, and the sponsors are aware of this, the Home Office is taking drastic action in taking the sponsorship licenses from these businesses. These businesses have now become aware that that is a big issue for them, and they think that they can get over it by reporting you to the Home Office, that either you've stopped working for them or you haven't reported for work. Clearly, that's a problem, because if you haven't reported for work, they have a duty to report you. And if the arrangement between you and them is that that is how it's kept, they are now reporting you. So this is to help you to be very cautious if you know that you fall within the category of migrants that I'm going to deal with. The first thing that you must watch out is that the Home Office has the power under the immigration rules, specifically Part 9 of the immigration rules, which relates to cancellation of visas. Paragraph 9.27, for migrants who have failed to work, have failed to report, or have stopped working. When that happens and you are reported, your visa will be cancelled. For sponsors who report this, they also have a duty to report if you're not working. And that is what they've taken advantage of. For migrants who came with their dependents under paragraph 9.24, their visa could be cancelled. Every paragraph I mentioned is discretionary, which means that the Secretary of State may give you 60 days or may not. The problem for some people is that when they are given the 60 days, it means that they need to find a new sponsor or switch to a different visa category. This is what I always advise people. If you're here and you know you haven't reported to work, be mindful that your visa may be cancelled. If you're here and your sponsor is not giving you the full hours, both yourself and the sponsor are in breach of the immigration rules. And therefore, if the Home Office becomes aware, they will cancel your visa. The other issue that I need to raise is that if you know that you're not attending work, you're sponsored but you're not attending work, your visa is going to be cancelled. The sponsors have also become aware that the Home Office is now taking active steps to cancel their sponsorship because they've brought in people, they haven't provided them with work, or even if they provided them with work, they haven't provided them with the hours that they said they were going to provide on the COS. So some sponsors, they think it's smart for them to do, to keep their sponsor license, so they are reporting you. Just be aware that if you don't attend work, if you don't report to work, if your sponsor is not giving you work, if your sponsor is not giving you the hours, or if you're here as a dependent and you don't know where your main applicant is, you don't have any contact with them, my advice to you is to make arrangements to switch and move away, because you don't want your visa to be cancelled and only given 60 days. It's a problem that we have identified in the community, and it hurts me so much that our people who have been brought here do not find the necessary support that they need. And when this happens, some of them unfortunately overstay, which means that they are switching to different categories become almost impossible. So my advice to you is that if you know that you're not going to work, you don't have hours to work, your hours is short, your sponsor is not providing you with the necessary support, please move on and find a new sponsor or switch to a family route. If you want to know how to switch, I've done so many videos. Go to our profile, you will find the videos there that will support you and assist you and direct you on how to switch. I hope this helps someone. But if you want to contact us, please, the numbers are going to scroll in a minute. Call any of the numbers and we'll be glad to support you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Go to Facebook. Welcome back, and if you want to contact BWF Solicitor 0208 493 7340, or in emergency situation 077 127 61884. I remember I told you about the assessment of good character for British nationality, which now includes entering the UK illegally. Now, since the 10th of February 2025, any history of illegal entry into the UK will typically result in refusal, although exceptions may be considered on or in exceptional situations. In all cases, the Secretary of State has a mandatory and discretionary duty to consider individual mitigating and exceptional circumstances in making a decision. The case is the one between Al Enain versus Secretary of State for the Home Department. This was a 2019 England and Wales Court of Appeal case 2024. And with that, let me ask you this question before I even go for the explanation. Let me ask you about this scenario. I was talking about my friend Brian Malgimpo, who had traveled to the UK at the back of a lorry in 2010. 3 years later, he applied for and was granted limited leave to remain as a parent, relying on a child who is a British citizen. He has since 2013 had 3 more British children. 10 years later, he was granted indefinite leave to remain. In 2025, which is this year, he consulted you. And I mentioned that last week we talked about the disclaimer. When you are giving advice on these things, make sure you are certified and authorized to do so. So let's assume that you are authorized to do so. So he consulted you to apply for British citizenship for him. He said he had heard that because he entered the UK illegally, his application would be refused under the good contact requirement. So, what advice would you give him? Would you say to him that he should not apply as he entered the UK illegally? Are you going to tell him that he can apply because he has indefinite leave to remain, which means he has been forgiven? Or would you say that, Brahma, you can apply, however, you must have a representation providing reasons why your case is exceptional and raise mitigating circumstances? Well, I'm not going to ask him to answer the question, but I'm asking him to help me explain the what do you call it, the nugget where we have that case in 2019. Asma, help me, please. How do I explain this?
So, yeah. Right. So we know that prior to the introduction of the changes to the suitability rule for nationality, which came into force in February, the government was clear that if somebody had entered the UK illegally, after a period of time, they are okay. After a period of time, 10 years, you're okay. But now the government is saying that you are forever wounded, so that once you came illegally, it will haunt you forever. So the highest you can get to is indefinite. You can't cross that bar. So, but the wording is what is crucial of the rule. The rule is that if somebody entered the UK illegally, then the person may not be of good character. And so the person's application will be assessed on the basis that they entered the UK illegally. And for that matter, such application will normally
be refused.
The operative word is normally. When somebody says that you will normally be denied entry to the premises, what does it mean? Does it mean you will always be denied? So you will normally be. Normally means that depending on the circumstances, we will not allow you. Depending on the circumstances, you will be allowed. So it has two-edged approach. And your aim as a caseworker for somebody like that is to look at how to mitigate it for them. So, and if you, as you read the nugget, there's a part which says that, please, go right, it says since 2025, February 10th. Go on for us.
It says any history of illegal entry, any history of illegal entry into the UK would typically result in refusal, although exceptions may be considered in exceptional circumstances. And in all cases, the Secretary of State has a mandatory and discretionary duty to consider individual mitigating and exceptional circumstances in making a decision. That's what it says.
So there are two duties. The Secretary of State has mandatory duty and discretionary duty. So if you're a caseworker for a client like that, your aim is to tilt toward the discretionary duty of the Secretary of State, to get the Secretary of State to be sympathetic to the mitigation or exceptional circumstances of the individual. And the case of this is 2019 case, and you see that this case was there before eventually the government said that we have changed the rule and we have made it permanent for people who came illegally. But producer will take us to what the caseworker will look at in making such discretionary assessment or mandatory assessment. Producer, if you are there, take us to the good character assessment threshold for applications, and we go. If we just as we did, give us.
Okay.
And
so we're looking at the one that has been highlighted.
Well, so yeah, let's read the highlighted part, please.
Yeah, then it says that an assessment of whether or not a person is of good character on the balance of probabilities must take account of all available information concerning the applicant's character, weighing any negative characters around criminality against mitigating factors such as contributions a person has made to society or any significant proportions of a person's life spent not offending.
All right. So here, when it comes to the assessment, there will be other factors that the Secretary of State will have to be considered. If we scroll down, we'll get to a point which talks about illegal entry to the UK.
Okay.
And mitigations. And because the nugget looks specifically at illegal entry, if I enter the UK illegally, what could be the reason? Is it that I entered the UK illegally because I intended to, or I entered the UK illegally because I had to, for safety reasons? If somebody entered the UK for safety reasons, then the Secretary of State will have to consider the exceptional circumstances. Somebody getting to the boot and all those people. Why would they do that? They may be fleeing persecution. They may be fleeing war and so on and so forth. So it's a matter of life or death situation. Flee for your life.
Okay.
If I'm able to flee for my life and I end up in a hostile community and they're able to understand my story and accept me, I have succeeded. And so even though the person might have entered the UK illegally, what the person will have to do is to look at why they did, the mitigation, and whether there was willful intention to enter the UK illegally or they had to find themselves in that situation for the purposes of fleeing to save their own lives. And therefore, under the circumstance, once you assess, your aim is to let the caseworker know that there is exception to the standard rule of illegal entry, and my exception is XYZ, and borders on human rights and protection of life, and on the basis that if I had not done that, this potentially would have happened, and so they have to consider. And since being in the UK, I've never offended or been a pain to the public or become nuisance, and therefore all these things must be put together on a balance of probabilities to make a holistic assessment to say whether this person should be allowed to continue to remain to become a citizen or not. And that's why it says that even though the rule is that if you enter UK illegally, you won't get to become a British citizen, it also says that the Secretary of State can consider discretions and allow you to become a British citizen. It's a case by case, and your job is to raise your mitigation circumstances, argue on the point of exceptions and discretions, and plead to the Secretary of State to consider that you are a person of good character, regardless of the fact that you found yourself in the UK illegally at the beginning.
So would you, as maybe the counsel of somebody who's been in the UK, entered illegally, but for all their life, for several years beyond, I've been into charity work, I've volunteered to ensure that the community is safe, has done so much to bring up good value in the community. Such a person is saying that, well, I've been of good character, I've been contributing, I've done this, that, and the rest of it. Would that be of an advantage to such a person, lawyer?
Yeah, all those things will contribute. But producer, let's go back and look at nature of the offense, because they will look at the nature of the offense at the time. We look, and then somebody who entered illegally, the offense would be that you came illegally. But entering illegally, is it an offense? It's an immigration offense, but not necessarily a criminal offense. And so, is there a reason for the person committing that immigration offense? So, if you go down to the nature of the offense, please, because there are a lot of people who have gotten to the point of applying for naturalization. But because they came to the UK, there's no proof that they entered legally. They think that's the end of them, but there's a way out.
Okay. So the nature of offences, under that, we say that you must consider the nature of offences or the behaviour that led to other disposals. Antisocial behaviour, drug use, or violence may indicate that the person's character is such that the refusal would appropriate, particularly if there's a pattern of such behaviour on the basis of causing serious harm.
So that's point one.
That's point one.
So you assess to see whether there's a pattern. So somebody who came illegally and has been positive throughout, and has even been granted indefinite leave to remain, contributing to society, community, and all that. Can we see any pattern of misbehavior? No.
No.
Are we then going to say that it would be okay for the person to be allowed to stay? Potentially, yes. Then we move on to age at the time of.
So it's telling the caseworker that they must consider the applicant's age at the time non-custodial sentences were imposed.
So this is for those whose issues are based on criminal activities. Even those people have exceptions.
Okay.
Even those people. How much more somebody who entered illegally, but they are not bad. It's a circumstance that brought them to the UK illegally.
Okay.
What does it mean? That means they came without aeroplane, without going through the border immigration. But if I didn't go through immigration, does it mean I'm very, very my behavior is so serious and harmful? Not necessarily.
No, not necessarily.
You go to exceptions. If you check the exceptions for us.
So we're looking at a exceptional or other circumstances, and it talks about other mitigating factors. We could scroll up. It says you must also consider whether the applicant has demonstrated genuine, meaningful attempts to change their behavior and comply with the law that may indicate, on a balance of probabilities, they are now considered to be of good character, despite earlier offending. A long period of time with no offending will be a more positive factor than a short period of time. An applicant may have also been involved in activities that indicate they may be of good character. For example, they may have engaged with programs or activities aimed at addressing the cause of offending, such as, but not limited to, treatments aimed at reduction of alcohol consumption or drug dependency and anger management courses, and also actively engaged with voluntary work, charity work, or actively promoted the reduction of crime. So as I was asking, I think this is kindly and clearly stated in the guidelines as to what could help me have some
and scroll down to producer, please go down for right. You get to a point where it says citizenship will not normally be granted. Down, that is after pending charges. After pending charges. There. So, there. So what I just say, citizenship.
Okay, citizenship will not normally be granted to a person who has a pending charge of persecution.
So that is why sometimes if somebody is applying for naturalization, there's pending charge, criminal charge, they'll hold on to the assessment. But all the points we've raised so far has nothing to do about somebody who entered the UK illegally.
Okay.
So even those people that this whole scenario is about, you can see that if we stretch it further, they may have genuine reason for entry. And for that matter, the discretion which is within the rules must be applied in their favor.
So if I entered, for instance, genuinely, yes, but I can't find my evidence of entry, for instance, my passport, and I have had to renew my passport or even gone for another one from the embassy or the mission of the country from which I came. Would that be something I can depend on to say, well, I entered legally, but I can't find the evidence, even though I have identified myself along the line? Could that be a mitigating factor?
Yeah, but if you have already accepted that you entered illegally, what it simply means that it didn't come through the orthodox way. But we want to know why it didn't come through the orthodox way. So we have to then check the circumstance of your entry.
Okay.
If the circumstance is such that this is what a normal human being would do, under the circumstance.
Mm-hmm.
Then you came illegally, but your intention is not illegal.
Oh, okay. Okay.
And we tell the Secretary of State to exercise discretion within the rules. But there's mandatory and discretionary consideration.
Mm-hmm.
So the mandatory consideration where it's obvious that the person knew what they were doing. So no, you are not good from the beginning. But the person didn't know what they were doing, but they were saving lives and themselves. Then should we punish them for saving their own lives?
I know.
There's a case I did. So the man applied for naturalization.
Okay.
He was refused. He did the application together with the wife. The wife got it, he didn't get it. So they came to me, two options. Either we fight it or we put in a new one. He decided that we put in a new one. Why? So I reviewed their case file from their previous applications. And in a cover letter written by the previous lawyers, long time ago, that was about 2013, when they were applying for indefinite, for two and a half, they had written in the cover letter that my client came to the UK under false name and passport.
Obviously, then came with a
So I
passport.
said, you know where your problem is coming from. But even that, the person got the 2.5, limited, and got the indefinite. And now going for naturalization, and they picked that up. And I said that, well, coming under false name and passport means that you came illegally. And the word false appears that you knew what you were doing. And that will fall under mandatory. But the criminal intent was already there. And that's why they picked it up. So my job then was, what do I do to assess it so that it will fall within the discretionary consideration by the Secretary of State? And what I did was to look at the mitigation. And my argument is that from the instructions my client has given, it appears that the previous handlers got it wrong. He came with a different name. Whilst in the UK, he changed his name. But that different name has evidence of the passport he came with and that name. So he's changed the name for reason, even though he did not go through the process to have a deed poll done. But it doesn't mean that he came with a false name. False name means that it's somebody's name, but this is his own name.
His own name.
The passport is also here. And you can see that the picture here is the same as this
picture there.
Even though it was a long time ago, somewhere 2000. But you can see the semblance is there. And so it's obvious that there was a mistake on the part of the handler at the time with the phrase false name and false blah blah blah. And so the implication is that, and for him to be considered for limited leave to remain up to indefinite leave to remain, since he hasn't committed any offense and all that, and I pointed out the mitigation that should be considered, and we put in the application again, making strong case that his application will be one of the applications that must be considered on the basis that this should not be refused and that it should normally not be refused. Because the rule says that it will not normally be refused, isn't it? So if it will normally be granted, which one will normally be granted and which one will normally be refused? Right. This one should be one of the ones that should normally be granted. And these are my arguments. And we are waiting for the decision.
Well, I know definitely when the decision is arrived at, you would share with us when we have a situation like that. So then, my friend, very Malbimpe, what advice would you give him, ladies and gentlemen? Would you ask him to not apply as he entered into the UK illegally? Would you ask him to apply because he has indefinite leave to remain, which means he has been forgiven? Or he can apply, however, he must make a representation providing reasons why his case is exceptional and mitigating circumstances. Think about this. We'll come back to this at the end of the program. But in the meantime, remember, we're doing this courtesy BWF Solicitors are trusted partners when it comes to the law. If you need any legal advice, you need any legal support, if you would want to get support or representation when it comes to your appeals and all other applications, business support, and the rest of it, please speak to BWF Solicitors 0208 493 7340. Thank you, BWF Solicitors, for for helping us bring the community and the law live on BWTV. And remember, we're live at BWF Solicitors at BWTV UK, both on Facebook and YouTube.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
It's the community and the law, and we come to see BWF Solicitors. The lines are active. When we would have gone into the discussion and discuss what we need to look at, you can call in later on 0208 493 7345. But in the meantime, we are looking at judicial review. It's not all the time that when you put in an application to the Home Office that they grant it straight away. You may not have satisfied every condition. You may not have met every criteria. Or for some reason, the decision goes against you. What are the options available to you? You apply again. You ask for administrative review or a judicial review. Maybe some details with that. I'll leave that because that's what we're going to discuss. But what is that option, the judicial review option, when the decision does not go in your favor? How do we know that this is the option we should take? When we do take that option, what does the law say? What process do we follow? What implications there are? Lawyer Charles Asma from BWF Solicitors, as you have heard him, vividly explained a bit about the good character situation. It's going to take us through this one as well, very vividly. Lasma, good afternoon once again, and I thank you for making time for us. We're looking at judicial review for a UK visa user. What are we talking about? What are the processes? And how do we even look at what the law says to apply to our situation? We'll come to you now.
Thank you very much for your time, ladies and gentlemen, viewers and listeners. Today's conversation is crucial because we may have heard about appeals, we may have heard about administrative reviews, we may have heard a bit about judicial review, but we don't really give it a thought much. But we think that it's something scary somewhere. So we hover around the surface of But today we are going to dig deeper into what further remedy is there. Last time on the show, we talked about remedies after refusal. And remedies are your rights. What it means is that if you are not happy with the reason, what can you do? And the reason for refusal could be that you don't qualify, you don't meet the rules, or that they feel that they wouldn't want to give it. It could also be that it's not even a refusal, but your visa has been cancelled. This afternoon when I was driving, somebody called that the home office called me yesterday that I have to come and report that my skilled worker visa has been curtailed. What do I do? So I said, don't worry, come on Monday to the office. Let's have a conversation. Why will your visa be curtailed? Why will your application be refused? What can you do? Can you take action? Yes, you can. And one of such actions you can take is to go for a judicial review. A judicial review simply means that you are not going to the Home Office for them to administratively review it because you think they have made an administrative error. You are not also going to the first tier court for them to review, decide whether the issue they have raised is made out or not. You are going to the upper court, what we call upper tribunal, for them to consider whether there's any reason in what they have done of refusing your visa. So most of the time, once you are not given any remedy at all, the obvious remedy for you to go for or to exercise is the judicial review remedy. And normally judicial review will be for applications that has no remedy offered. So once you are refused a visa and they don't tell you what you can do, you can go for judicial review. If your visa is cancelled or curtailed, you can go for judicial review where they have not told you appeal. If they ask you to appeal, then you cannot also go for judicial review because they have told you specifically what remedy to exercise. So visitor's visa, you can go for judicial review if you are refused. Cancellation of visa, you can go for judicial review. Administrative review that has been decided and maintained, you can go for judicial review. So whenever you can't go for appeal, you can go for judicial review. That's the starting point. Our job this afternoon is to look at the specific rules and also how to approach it and what happens if anything happens, or at the end of it, what are the implications of doing it or not doing it. So as we have already indicated, judicial review is a request to the upper tier tribunal or upper tribunal, the immigration upper tribunal, seeking the court to review the decision. The rule is that you should go to the court to ask them to do so for you within 90 days of the decision. The 90 days of the decision will start from the date the decision was made. That is the refusal or cancellation decision. When you have received the original decision, your job is to tell them that I want to go to court to have the court to review the decision because I think certain factors are present to suggest that it is not fair. One, it is illegal in terms of the approach that the caseworker did not use the right law or did not apply the law correctly, and therefore the refusal test or approach was wrongful or unlawful or illegal. So you can seek judicial review on the basis of illegality or procedural impropriety. Again, you can seek judicial review on the basis of unreasonableness, where even though they apply the test correctly, it doesn't make common sense to think that anybody will conclude this way. And we say it is unreasonable, it is irrational, or it is perverse. When these factors are present, then you are going to the court, that is the upper tier court, to ask them to review the decision, confirm whether it is legal or it is rational. The court will conclude. If the court concludes that it is not rational, then you are right. If the court concludes that it is rational, then they are right. But the question is, what are the specific approach that we ought to take. We will be coming back with the procedural rules that you need to follow as far as the rule or the law is concerned. And we'll also touch on the process, we'll conclude on the implications, and will allow you to ask the question.
I know definitely your questions are ready and you want to pose them. Lasma is ready to take us to the procedural rules and what are they based on? Are they in those big law books or they are in the guidelines as we have? We will be getting into that. So get yourselves ready, sit back, and also invite people. Remember, we're live on Facebook and YouTube at BWTV UK and BWF Solicitors. You can send a text to 07399 208 468, 07399 208 468. And when the lines are active, you can call us on 0208 493 7345, 0208 493 7345. I know some people have started rushing coming on the phone lines. It's not active yet because we are there to delve into the discussion proper. So just wait for us and we'll come back to you. But you can keep texting 07399208468 and we'll keep that there. And also another opportunity for you to do that is to keep your comments in the comment section down below, either on Facebook at BWF Solicitors or BWTV UK, and also on YouTube at BWF Solicitors and at BWTV UK. Now, Leasma is here, and I think first things first, what are the procedural rules that we need to follow when we making or we go for judicial review? Lawyer.
Yes, so producer will assist us at this point. Producer, if you are ready, please take us to the rule book, which is our Bible or Quran for this conversation. Part 4. Please scroll down to part 4. Part 4. Rakuku will do the readings for us. First, second, third readings.
that's morning mass. Now this one is afternoon mass live on BWTV. Evening mass. So part 4, we have part 2. This is part 3. Let's go to part 4. Judicial review proceedings in the upper tribunal. So, so let's get into that.
So let's go to the key point. It says the application of this
part to judicial review proceedings transferred to the upper tribunal.
And that's why the application for permission to bring a judicial review. So this is important.
Okay.
You need permission to bring a judicial review.
Or you just can't straight away go in and say, well, I ask you to review this for me.
You need permission, you have to knock on the door.
Okay.
I want you to stop and consider this for me because I'm not happy with the decision those people have made against me. So you need permission. We call it judicial review permission application. Then you move on to special provision, acknowledgement of service, decision on permission, responses, and so on and so forth. But let's look at the permission, Rule 28.
So Rule 28 talks about, well, there have been changes. So let's look at the tribunal procedure, upper tribunal rules 2008. Section 28 is up to date with all changes known to be enforced on or before the 24th of October 2025. Remember last week when we were dealing with situations like that, there were changes, but they were going to reinforce what is already there. So if there were any changes or thereabouts, as of the 24th of October, which is the day before today, they were up to date. Now, applications for permission to bring judicial review proceedings, 28.1 says a person seeking permission to bring judicial review proceedings before the upper tribunal under section 16 of the 2007 Act must make a written application to the upper tribunal for such permission.
Right. So you see that it's making reference to the 2007 law. This is 2008. So the core law, the root of the law stems from the 2007. So there's Procedure Rule 2007, and there's Procedure Rule 2008, which is the amendment of the 2007. And it's saying that 2007 Section 16 or Rule 16 will take you to the process of making application, which in 2008 rule is Rule 20 or Section 28. And it says that you have to do so in line with that. And all that is telling you that make an application to court. And the application is on a form called upper tier. So it's called UTIAC. UTIAC simply means that Upper Tribunal Immigration and Appeal Chambers. So UTIAC, Upper Tribunal Immigration and Asylum Chamber. Immigration, so at UTIAC 1 is the Form 1.
Okay.
And Form 1 is where you need to make an application to court. There's a cost of £179 to pay. So you lodge it online. Before it was paper, and now it's online. On the form, it will ask you, have you done what you must do before coming to us?
Which is?
He who wants equity must do equity. And one of the things you must do is to go through the process. If you are not happy with me, and you want to complain about me, what is the common sense thing to do?
So I tell you that
First, I'm not happy if you don't do anything about it. I will go further. Is that not common sense? So if I don't do anything about it, you are complaining to somebody who is the referee, and they call me, they say you've done this. I said, I don't even know. He hasn't even come to me. They, you haven't even resolved it at home. And you are coming to us, wasting our time.
So that will be thrown out.
So it wouldn't be entertained. So the first thing is to go to the person. In this case, our person is the Home Office. So we'll go with what we call pre-action protocol.
Okay.
That is notice
before
action.
You're going to go to court if they don't do anything about it.
Exactly. So you put them on notice that we intend to seek judicial review. So you present a pre-action protocol letter based on the decision to refuse your visa, or based on the decision to cancel your visa or curtail it, or whatever. Then you point out the reasons they cited, the fact that you disagree on the basis of the following reasons or the law, and you tell them that if they don't do anything about it, you go further to seek judicial review. You put them on notice.
Okay.
What we call notice before claim or action. They have to consider. So at that point, what do? You've told me that, so think about this. What will you expect to happen?
That they look at it
to hear from me.
Yes, and tell you
to hear from me. So if you haven't heard from me, what will you do? Will you go or you still wait?
You still prompt them to say, I'm waiting for you.
Ordinarily, you wait.
Okay.
Within the rules, it will tell you that don't wait at risk.
Okay.
And what's the risk? The rules say that you have 90 days from the day of the action which you disagree with to seek judicial review.
Okay.
And day one, you have sent them notice that I want to take action or seek judicial review. And you start counting 90 days. The 91st day will be too late. So your review application must go latest by the 90th day from day one of the decision.
Okay.
So if you are waiting 89 days, you haven't heard from them, 90th day, you haven't heard from them, what do? This time it's not the law, common sense. What do?
You knock on the door of the court.
If you don't, what happens? You are late. You're late. Well, it says 90 days. So then you go and tell them, I was waiting for them to come back. Then you say, but we told you that 90 days come. So at this point, when you know that they are not coming, you know that they are ignoring you. So do what you had to do. Like knocking our door. So 90 days is standard. Then,
can I do it on the 80th day?
Well, again, what if they come back on the 86th day? But usually we don't wait till that. We tell them that if we don't hear from you within 14, we want to see judicial review. They will come back and say, all right, this we are considering your pre-action protocol request, and we'll give you a decision on this date.
Okay.
So when they give you a specific date to wait, will you rush to go?
No, you have to wait because you have responded.
But they've responded. In that case, the clock will start what? Ticking again. Not from the beginning,
but from the time
point you heard from them.
Okay.
Right. So we are talking about the procedure, the law. And so once they come back, now you hear from us by, let's say, 31st of October. You wait up to 31st October. Then if you don't hear from them by 31st December, you can go 1st November to knock on judicial, the upper tribunal door with your notice.
So if I get it right, when you have complained to them, your 90 days starts from when they made the decision to when you would have or not heard from them and you want to proceed to court. But when they respond within the initial 90 days, your another 90 days starts to count from when they responded. Is that right?
Exactly.
Okay.
That is one point. The other point is where you are late in telling them that you seek to take them to court. That's seek judicial review.
Okay.
So that the refusal came, like the person who has just told me that curtailment. I'm going to have the conversation on Monday. Immediately, I will tell her that, well, if you instruct me, we have to go to them with pre-action protocol. Because the court will ask, have you first done the pre-action protocol? The only time you will not do pre-action protocol is when there is imminent deportation or removal.
Okay.
So that one, we don't have time for this.
Those things. Okay.
But where there's no danger, then you have to do the right thing. So we go to them. But if we go to them, let's assume that this person does not instruct till 1 week to the 90th day. Then they have only 1 week to go. If the person has instructed me, then on the 85th day, then on the 86th day, I'll send a pre-action protocol notice. Then on the 87th, I'll send my judicial review. I won't wait for them to come back.
Because you are out of time.
But my job is to protect the interests of my clients.
Okay.
Within the rules, though.
Yeah. Now, we're still talking within the rules. Let's say for some circumstantial situations, I go beyond 90 days. Would the court ever listen to me?
So, again, two things. There's a maximum I'm going to quote, and there's another maximum I'll quote after that maximum.
Okay.
There's one which says that equity sees has done that which ought to have been done. That means if you have to do it within 90 days, then you should have done it within 90 days.
Okay.
So if you did it after 90 days, you can't come and say that I meant to do it in 90 days. If you meant to do it in 90 days, why did you do it after 90 days? Equity sees has done that which ought to have been done in 90 days. So if you are doing it after 90 days, then that is not fair on anybody for your delay. However, there's also another maxim which is that he who wants equity must do equity. So if you have delayed and equity has been defeated, you have to go and tell them why the delay is warranted. For example, I have delayed because the people said that I should wait for them to get a response. I have delayed because I sent my pre-action protocol and I was not hearing from them. I have delayed because I was sick unduly. This is my evidence. I have delayed because of those circumstantial factors supported by evidence. Then the procedure rule will tell you that when you are late, you have to first make an application for extension of time to bring your judicial review as part of your application.
Okay.
So if you are late, you don't just come as if you are okay. You say, I'm sorry I'm late, don't you? Common sense.
Yeah.
That's what the court is saying. When you are late and you have good reason, bring the reasons, put them on paper, and add it to your application. So they will ask you, is the judicial review application brought in time? You know whether it is in time or not. If it is out of time, you say no. Then they will ask you, have you added extension for time to still bring the application? And you say yes. Because if you say no, then you are being
obviously.
You are what was the word? You are disrespectful to the court. You are late, and yet you are not showing remorse. So you say yes, I'm late. This is my permission for application for extension of time to seek permission for judicial review.
So what time normally would they allow when you are late?
Well, again, delay equity. So when you delay and you become aware of the delay, immediately act.
Okay.
So when you are already late and you're asking me, how long should I wait for to come?
You have been unreasonable.
You're already late. So there's no time to wait again. The moment you became aware of the lateness, you act with your reasons why you are late. But if you are late, you are bringing the application, let's say on the 100th day, then you are late for 10 days, right? If the reasons are tenable, fine. But if you are super late for 100 and let's say another 90 days, that's 180 days you've taken. But you needed 90 days. You've taken another 90 days late. So what was your reason for the lateness? Can you account for each day of the lateness? When did you become aware? Well, you knew 90 days. You were aware you were late 1 day, 2 days, 3 days, 90 days. Would that delay defeat equity? Yes. Because it is too much or too late.
Okay. Well, folks, if you just joined us, we're live on BWTV and we're looking at judicial review for a UK visa refusal. We're looking at the law, the process, and the implications. The procedural laws and the rules. Lawyer has taken us through that. So we have knocked on the court's door. They have allowed us to bring in the case because we have done what needs to be done. What goes in there in that queue, as part of the process? What do we do? We've looked at the law, and what is the process? Right.
Yes. So the first process we pointed out is that you have to send a pre-action protocol notice to the respondent or to the caseworker, the person whom you are not happy about, to say that for these reasons we are seeking this remedy and we are putting you on notice. They may come back to say that fine, we have changed our mind, so don't worry. Or they may come back and say, go ahead, whatever you want to do. I didn't want to say the other one.
They are daring you. Go ahead.
In this case, they are saying that decision is maintained. But when you send a pre-action protocol notice, either they come back to maintain the decision or they come back to reverse their own decision.
Okay.
Then you don't have to do anything. But when they come back, most of the time they will come back to maintain it. Then you have to go
for the
to the next level. So the first point is, have you sent pre-action protocol notice? You only send at all times, but when necessary, you can forgo it. And when do you forgo? You forgo it when it is not possible to go through the judicial pre-action protocol. But even that, you just send them quick notice that you want to do this and go ahead to do whatever you want to do. In that, it's a tick box exercise.
Okay.
So most of the time, make sure that you have sent your pre-action protocol notice. Whether you are going to wait for them to come back or not, send it. When you don't have time to wait, move to the next stage. When you have time to wait, wait for them. Then pre-action protocol decision comes and it is maintained. Then your 90 days will start from there. Then we put in application for permission to seek judicial review. And the permission to seek judicial review must have certain things. And here, producer, please help us. Take us to where you were before part 4. So go back to part 4, the application process 28, and go down to 4. 28.4. Yeah, so that 28.4.
Okay. 4. So it says the application must state the name and address of the applicant, the respondent, and any other person.
Which application?
The original application.
The judicial
review application. Okay.
Because you are making application for permission to seek judicial review.
Right.
So that application itself is not judicial review.
It's not even the case itself.
No, it's permission for the court to say, we have granted you permission
to bring the case before us.
Exactly.
Okay. So yes, the application must state the name and address of the applicant, the respondent, and any other person whom the application considers to be an interested party. The name and address of the applicant's representative, if any, an address where documents for the applicant may be sent or delivered, details of the decision challenged, including the date, the full reference, and the identity of the decision maker. We also have to state that the application is for permission to bring judicial review proceedings, as lawyer had explained earlier on, And the application must also state the outcome that the applicant is seeking, and G, the facts and grounds on which the applicant relies.
How many items are here?
1, 2, 3, 4, 5, 6, 7.
Whose responsibility it is to point to cover all these?
The person who is sending in the application, the person who wants judicial review to be made for
the applicant.
him or her. Yeah.
So now the main thing is what you are seeking. You want the court to do something for you, so you must tell them what you want. So if you miss that point, the court will say, "Well, there's nothing. You haven't told us what you want.
You just come up with a story. You haven't told us what you want."
Exactly. Just like somebody talking. Sometimes when clients are telling me, they will talk for 1 minute. I say, "So what is the question?" But you've called to ask me a question. So what's the question? You are going to court. So what are you seeking the court to do? You want the court to quash or set aside that decision, either to remake their own decision in your favor or to cancel the cancellation.
Okay.
If it's cancellation, or tell the Home Office that the refusal doesn't make sense, so they should grant you the visa. So your job is to make a specific request to the court that I want you to review the decision and give me this. If you don't point it out, the remedy you are seeking, then you've wasted time. That application cannot be looked at or considered.
Okay.
The second, like G, talks about grounds. And grounds simply means why, your reasons. You can't just go to the court to do something for without giving them
the reason why,
reasons within the law, why the Home Office is wrong and why you.
All right.
And why the court should side with you. And that's important. Because even with the grounds, if you get it wrong, if it doesn't make sense, the court can even punish you.
You've wasted their time.
Wasted that they bring a ground that doesn't even make sense. They can even punish you. If you're a lawyer, they can report you. If you're a normal person, of course, they can just tell you off. But if you're a lawyer, it's risky. So you sit down and prepare thorough grounds. And that is the grounds. Either the grounds could be 1 or up to any number. And you are pointing out the issue and you are addressing it within the rules and telling them that it is wrong. For example, if it is visitor's visa, if you are visiting your family, we are not saying that they can't refuse you visitor's visa, but we're also telling them that human rights is enshrined in the 1998 Human Rights Act and also enshrined in the European Convention on Human Rights, what we call family life. And so if I'm visiting my family in the UK, you are denying me and you are taking away my Article 8 right, isn't it? It is your country, yes. But so far as my family member is there, I have the right to be there, to say hello to them and come back. Whether you think I'm coming to stay or not is not the point. The point that I have a right. So there are judicial review applications we have made to challenge visitors' visa decisions that have been successful because the argument was on human rights.
Okay.
So we point out the grounds. If it is cancellation, recently there was one that the Home Office has just come to say that we are sorry, we are going to reverse their decision, blah, blah, blah. We told them that yes. So the person made application for the child. And he said that the child's application included fake document. But you've gone past that child to bring your anger to the parents. That is what we call remoteness of danger.
Okay.
Because the danger should be with the children. But we are saying that if the children can commit this offense and the children can act, they want to know who acted.
Okay.
So we pointed out that yes, you are right to think that the parent did, but you can't bring the punishment to the parent. Again, we pointed out so many other reasons. Those are the grounds. The grounds must be founded in law.
Okay.
So it's not a factual argument. It is legal argument. Pointing out the case law, pointing out the procedure that the Home Office caseworker should have followed, and also pointing out the statute. It could be based on children, based on human rights, or based on anything. But you point out the law and you tell the judge that this is the law, and they didn't follow the law. So what they have done is illegal.
All right. If you just joined us again, I would want to welcome you on board. We are looking at judicial review for reviews of this application. And we've looked at the law, we've looked at the process, and we're taking a quick break to let you in on our social media handles. And then we'll come to quickly look at the implications. But remember earlier on, we gave you the nugget and talked about the good character implications when it is that you are applying for naturalization. Now, the Home Office is saying that since February 10, 2025, any history of illegal entry into the UK will typically result in a refusal, although exceptions may be considered in exceptional circumstances. Remember, in all cases, the Secretary of State has a mandatory and discretionary duty to consider individual mitigating and exceptional circumstances in making a decision. This was based on a 9 versus Secretary of State for the Home Department 2019 England and Wales Court of Appeal case CIV 2024. Based on that, I asked you a question about my friend Berima Obimpe, who had traveled to the UK at the back of a lorry in 2010. 3 years later, he applied for and was granted indefinite leave to remain as a parent, relying on his child who was a British citizen or is a British citizen and has since had 3 more British children. 3 years down the line, he was granted indefinite leave to remain. In 2025, he consulted you as a lawyer to apply for British citizenship for him. He said he had heard that because he entered the UK illegally, his application would be refused under the good conduct requirement. So then I am asking, what advice would you give him? Would you tell him that he should apply? He should not apply as he entered the UK illegally. Are you going to tell him that he can apply because he has an indefinite leave to remain, which means that he has been forgiven? Or are you again going to tell him he can apply, however, he must make a representation providing reasons why his case is exceptional and raise mitigating circumstances? Think through this. We'll come back to do the last strand of our discussion before I take your lines, I take your questions on the line, and also from the comment section down below, and from the text message line 0739920848. It's still the community and the law, and it's brought to you by BWF Solicitor. Live on BWTV, and we are on the program The Community and the Law Live at BWF Solicitors, both on Facebook and YouTube, and at BWTV UK, both on Facebook and YouTube. We are discussing the judicial review for refused visa applications. We're looking at the law, the process, and the implications. We have already touched on the law. We have looked at the process, what you need to do. But when you have done that, what are the implications? You as an individual, does it affect you in applying for anything going forward or what? Last one. Now you have entered into litigation with the Home Office. It could be that when you approach the upper tribunal, they will tell you, listen, the decision of the Home Office would have to stay. So you don't have anything. When it comes to that, you and the Home Office, between you, is there going to be some acrimonial here and there? What are the implications of whatever decision that the courts will make?
Good. So the implications are: one, the court will agree and grant permission for review, and it will move to the next stage. Or the court will not agree and refuse your permission for judicial review.
Right.
And that's why the grounds are very, very important. But it's the ground that will convince the judge that this one makes sense. We have to look into it so that we can be fair to both parties. Now, there's also possibility that Home Office or the caseworker will also consider the grounds and come and tell you that the argument you have put across honestly makes so much sense. So please, if you can, withdraw so that we can settle at home.
Okay. It takes me back probably one step to the process. You have minded to give them notice that if you don't act and rescind your decision, I'm going to ask the court to review and grant me hearing. Now they look at the grounds and say, okay, yeah, you make sense. I need to consider that. Then they say, come back and we're going to review our decision. What do you tell the courts then?
Good. And because it's now with the court, it is not a matter of backdoor conversation. So they will approach and say that we don't want to go further. We agree with you. But because it's a procedural matter, can you say that you are withdrawing your case from court? Then once you agree with us, we will tell the court that we have agreed to resolve at home. To court, don't waste more time again. Court will then stamp it, and that becomes the order of the court.
That you should go back and resolve.
That's called consent order. Okay. So get to a point before the final decision of the court is made or permission is considered, that the respondent, which is the other side, the Home Office, will come and say that, can we consent or can we agree to resolve it? And tell the court that we have agreed to resolve it. And court will just rubber stamp our agreement. That agreement is called consent order. I'm going to ask the producer.
Before we go on to that, let me quickly ask this. Before who prompts the court to give the consent order? Is it the applicant or the respondent?
So all this one, remember the court is just a referee, arbiter. Between the parties are the respondent, the Home Office, and the applicant, the person who has been refused or whose visa has been cancelled. But this person is being represented by a lawyer. Home Office also will be represented by the government lawyers. So the two lawyers are working together.
Okay.
The one we'll be looking at is, it came to me from the government lawyers.
Okay.
So the government lawyers would have reviewed the argument because as part of your application, you must create a bundle.
Okay.
Bundle. So remember, it says that the decision, the blah, 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 including your evidence, and put it together and send it to court. Then you send it to the Home Office. They will review it. But the process is that when the court receives your application, court will give you confirmation that they have received it. We call it sealed application. Then you send it to the Home Office to say that court has sealed the application. In other words, received the application. And you fill a form called UTR 2, which is service. Once you serve them, litigation has started.
Okay.
They will review the papers, my argument, and come and tell me that, oh, can we sit down and discuss this? Or we think you are right. So we'll come up with points for you to consider. And if you agree to withdraw the case, we will also agree to do X, Y, Z. And that is why it's called agreement.
Okay.
And once we consent, they will take it to court for court to stamp it. And it is their duty to go and tell the court that we are resolving our home.
So we come to that document you were projecting for us, where the consent order is given. Shall we pick that one up? And it says consent order upon the respondent agreeing to reconsider a decision of 16 June 2025 to cancel the applicant's permission to enter the UK and issue a new decision within 3 months from the date a sealed order is served, absent special circumstances. By consent, it is ordered that 1, the applicant do not leave to do have leave, sorry, the applicant do have leave to withdraw the above claim for judicial review. The respondent do pay the applicant's reasonable cost to be assessed if not agreed, and any notice of commencement or bill of costs must be served in accordance with the guidance at www.gov.uk/GLD, and it's given on a date and signed by somebody for the Treasury Solicitor, Government Legal Department, all the details over there.
Yeah, I mean, we have left these details because these are public details. My signature is a public detail.
Oh, is that your signature?
Yeah, that's me. I'm representing this client.
That's one. That's a typical one for a lawyer.
We've taken the main part of that contains client details.
Right.
But I see that they came to me on when? 25th, right? The 16th.
16th of June 2025.
Yeah, so this was one of the cases. And been a lot of these ones. But then eventually they came 17th day of October. This is October 17th. So the decision
of October,
the decision and the challenge was made on the 16th of June 2025, where the person was told that their visa would be cancelled. Actually, it was cancelled because they used fake documents to make an application for their child to join them in the UK. And so we had to go to court to challenge that decision to cancel their visa. So whilst we are waiting, the application on the 16th of September, but that was when their visa, the last day for them to act, the 90 days. So we put it in, and by the 7th, they came back to tell us that, what did they say? Upon review, upon this and upon that and upon that, this is the consent. The consent is that you withdraw the matter from court. And what would they also do? They will reconsider the decision to cancel and pay our reasonable fees or cost.
Okay. Well, time and tide is a wait for no man. We have so much gone into these things, but I believe that if you, as I always say, it is always best for a layman to give his work for an artisan to do for them. So all these things, to pick up the arguments, know what the law says, go through the processes, and look at the implications for yourself and your family or whoever is with you doing the application. Listen, I would advise you, visit and contact a lawyer who knows what he or she is doing, and get them to put the argument and your facts and the grounds, as it is called, together for you to be able to do that. And if the grounds are solid, definitely, as we saw in this one, the Home Office may ask you to withdraw your application to court for a judicial review, and they will sit together with you, or probably reconsider their decision and reverse whatever it is that they have done against you. If you have a question, send a text 0739928468, or you can call us now 084937345, or you can put the comments in the comment section down below. We'll take a couple of them, and when we have finished, we will definitely ask you to put in the answer to my question. A lawyer will round up for us. Please, if you do a pre-action program for UK visit visa refusal and agree to reconsider within 3 months for a new decision, does it mean they will grant the visa? What due process do they follow at the reconsideration time? Lawyer, Kojibuate is asking.
Right. So when they say they will reconsider to issue a new refusal, which may be different from the original one, or they will reconsider to issue a positive decision. So reconsideration doesn't necessarily mean that it's going to be positive.
Okay.
But what it means is that once they reconsider an issue within 3 months, whatever they give you starts the process again for you. Or whatever new thing they give you becomes a new decision. Now you can again challenge. So it says that would they grant the visa? It is not 100%. It's 50-50. What due process do they follow? The due process that they will reconsider the argument you put forward in the pre-action protocol notice and check whether they are indeed wrong. If they still think they are right, they will reissue the refusal and say, we've looked at your PAP and we still think that decision is warranted. And so refusal is maintained. But that becomes a new decision and you can challenge again.
Okay. We have a friend on the line who has a question. Hello.
Hello, good evening, Brakwe.
Good evening, Mama.
Please, I have a question. I know you're nearly done. I'm married to a British citizen, and then I got my indefinite leave in March.
Okay.
I have two kids that I brought from Ghana, and the last month was 2 years. They also got their indefinite in June. So, is it possible to do naturalization for them, please?
Okay, Lawyer will answer you. He's right here.
All right, thank you.
Right. So you have received your indefinite, right?
Yes, please.
When are you doing the naturalization?
I've done it, but it's not out yet. But
Right.
My first one is getting 17 in January. So I can't pay out those ones. So I'm thinking that if it's possible, I should do it before January to go 18.
Right. So a child born abroad, right?
Yes.
Who is 10 years at least, right?
No, he's 17 now.
Who is 10 years at least?
Yes.
Yes. Who now has indefinite leave to remain, right?
Yes, please.
Whose parent also has indefinite leave to remain, right?
Yes, please.
That person can apply for discretion to be registered as a British citizen under the rules. And that person must show that they are of good character. Yeah. It's a discretionary application. That means the Secretary of State will consider whether to give or not. If they consider that they don't want to give, they won't give. If they consider that they want to give, they will give. So that those options are there. Because your child was born abroad and you have indefinite, you cannot register directly. So the child will have to apply to register as a child born abroad, living in the UK, has indefinite for 2 years, at least 10 years old, and want the government to consider for him or her to be registered to become a British citizen.
Okay, so I can do it now. Whilst he's been in the UK for 2 years last month.
Remember, I've taken you through the rules.
Yes.
And that's what I said.
All right.
Yeah.
Thank you very much.
So you can do it. Don't go and make a mistake and say, lawyer said I can do. I said you can do. I didn't say go and make a mistake. If you think you can't do it, get a lawyer to do for you.
Definitely, I will come.
All right. Okay.
Thank you.
You are welcome.
Thank you very much.
Thank you. Thank you very much. God bless you. We expect to have you. Bye. We expect to have you again with us on the program again, same time next week. Let's pick up some comments from the comment section either on Facebook or YouTube. Okay, the Chia Papa Kwame says, can EU settler who is not well and depends on Home Office make an application for her case? I'm thinking you depend on the local authority rather than the Home Office. Lawyer, I hope I'm right.
Make application for her kids. Are the kids abroad? I mean, you are EU national, even though you can't work. That is why you are not working. So not working wouldn't be a barrier to exercising your right to bring your family to join you under Appendix EU to the immigration rules. So you can, okay? And the EU, you don't have to show that you can look after them. Obviously, common sense approach. If you can't feed yourself, how will you feed your children? That's a secondary matter. But the core right is that your family members, i.e. your kids, if they are indeed your kids, can join you in the UK if you are an EU national settled in the UK. Whether you can look after them or not is a secondary matter. That is not part of the law.
Well, Kadaji, yes, that's the answer. If you need further information on this one, you can contact BWF Solicitors. The numbers are at the bottom of your screen, 0208-493-7340. Let's pick up another one here. And this one comes up, say it's from Philip. Please, you came on the care worker route 3 years. And your employer license was revoked, and for that you couldn't pay your required taxes on your national insurance, but your right to work is still active. In case I get a new certificate of sponsorship, can I apply for indefinite leave to remain after the completion of the new certificate of sponsorship. Lawyer.
Right. So those who have become stranded, it's now a common um, phenomenon. A lot of these people are stranded, and the government has put in place mitigating measures for them. One is that find a new employer. In this case, the person is not working, but their right to remain in the UK is still valid. What you need to do is to find an employer. Once you find an employer, it is the last employer that will sponsor your indefinite leave to remain. Obviously, during the indefinite leave to remain process, you are worried about whether they will check whether you've worked throughout the 5 years. The rule under indefinite leave to remain transition for care workers or skilled workers is that the employer who is going to support your indefinite leave to remain application, that is the last employer or the current employer, should one confirm that they have job for you. Two, confirm that the job will continue to be there after the indefinite. Three, confirm that they are able to pay you the salary at the going rate. And four, confirm that the salary will continue to be paid. All this must be in writing. If the employer is able to do that, support your application, then you are likely to succeed. If not, no. But the point of whether you were working and you were not working because of this and that, they know. And so, if a good lawyer is handling it for you and you have met the basic requirement for indefinite leave to remain application for skilled worker, then you should be able to make a very good argument in favor of your application.
Well, we'll pick a very last one on this because we have almost run out of time. Ritma Mitano, can a main applicant bring her kids if the dependent is refusing to give their consent? Lawyer.
If you say dependent, who is the dependent? Mame Tando, I won't rush to answer because there are details that are missing. Now, dependent may be that your husband, you are the main applicant. Your husband doesn't have to give consent because your husband or your wife, the dependent, the so-called dependent you are talking about, is not the other parent of the children. You're only supporting the application by providing their document, but you are the main person bringing them. So if you are the main applicant, then it's not a big deal. Consent must come from the other parent. But if the other parent is going to provide consent and the other parent is not in the UK, then it's a case for refusal because if there's consent provided by the other parent, then you are not going to prove that you have sole responsibility. In that case, the children must stay with the other parent who has given consent. So anytime you are considering to provide consent, be very, 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 five verys careful before you add the consent.
Well, and with that, I would want to ask you to drop in your answers to my quiz about Berimo Bimpe. Would you advise him that he should not apply as he entered the UK illegally? He can apply because he has indefinite leave to remain, which means he has been forgiven. Or he can apply, however, he must make a representation by the reasons why his case is exceptional and raise mitigating circumstances. We'll quickly rush through those ones with just the numbers and we see what lawyer will give us. James says it's number 3. Thank you very much, James. We go to Kojo Wiafe says it's number 3. Thank you. Next one from Eric Mensah says number 2. He can apply because he has indefinite leave to remain. He's been forgiven. Moses thinks it's number 3. Thank you, Moses. We go to Kofi Apia. Kofi Apia says it's number 3. Thank you, Kofi. God bless you for responding. Sally says number 2. Let's take about 3 more. Amasewa says number 2. Amasewa, thank you. Then the next one, which is the last one, Kwame says B, which is number 2. He can apply because he has indefinite leave to remain, which means he has been forgiven. Lawyer, which one of us is correct?
Right. So we are aware that there are instances where somebody may be refused and the person must provide mitigation and all that. But if we look at Mr. Obimpe's story, which is the key thing as to what exactly is happening. He came, and at the time he came, and we are told that 2010 and 2013 he applied and was granted leave, and as a parent relying on his child, and eventually had three other children and so on and so forth. The other key thing is that he was granted indefinite leave to remain as well. He said that he had heard that because of the his application will be refused. Our job now is, if it's for example, if you look at number one, he should not apply. Why shouldn't he apply? That means you are telling him not to even attempt. But he wants to become a citizen. So one is no.
Okay.
Two, he says that he must apply because he has indefinite leave to remain. Having indefinite leave to remain is not enough, because the rule says that you can be refused if you entered illegally. But we have to check whether mitigation is there. And it says that the fact that he has been given indefinite means that he has been forgiven. Okay, he can apply. However, he must make a representation providing reasons why this case is exceptional and the reasons why, and so on and so forth. So if we look at this carefully, ordinarily some people are given A, some people are given 2 and other. Between 2 and 3, we are saying that he should go ahead and apply because he has been forgiven. Why has he been forgiven? Considering the fact
Please hold while I try to
considering the fact that he has been given indefinite leave to remain, he has had other children, and so on and so forth. But even that, he has to make sure that even though he has been forgiven, he has to cite reasons why his case is an exceptional matter. So we go with 2.
Well, the answer to the quiz is 2, as lawyer has said. Since February 10, 2025, any history of illegal entry into the UK will typically lead to refusal, though exceptions can be considered. We're looking at the good character requirement of the 13th of February 2025, and lawyer has given a very elaborate reason and description of the situation. And listen, if you want any further advice, contact BWF Solicitor 0208 493 7340, or you can go to the various social media handles and you will be given the support you need. It's about time we drew the curtains down. But before we do that, tradition should never be quashed. So we go back to Lawyer Charles Osman. We'll give a quick summary of what we discussed today. I know we looked at judicial review for a UK visa refusal, the law, the process, and implications. What did he tell us? Lawyer.
Viewers and listeners, today we looked at judicial review. We said that if your visa has been refused or cancelled and you are not given right of appeal, you can apply for judicial review. Again, if you are given administrative review rights and administrative review did not succeed, you can go for judicial review. Judicial review is a remedy within the law, and you have to make the application to the upper tribunal of the Immigration Asylum Chambers to tell them that you are seeking a review because you do not agree with the reason which borders on illegality or borders on irrationality. And on that basis, the court should consider. You have to do so within 90 days from the date of the decision that is being challenged. And again, you have to send a pre-action protocol letter to the Home Office telling them that you intend to seek judicial review. They don't do anything about it. If you haven't heard from them and 90 days is getting close, go ahead to make the application to court. The application must be done on form UTIAC 1, which is called UTIAC 1 4, and you pay £179 as application fee. Court will consider the application and seal it. That means they accept it. After it's been reviewed, the application will be granted so that you can go ahead with the judicial review process, or it will be refused. If it's refused, it means that grounds are not challenging enough and that you cannot succeed on the basis of those grounds. So your application for judicial review must be supported by solid grounds that will convince the court to consider the application. The application for judicial review must also include the decision you are challenging. The application must be done within 90 days, as we have pointed out. you must pay the fee of £179. You must make the application online, what we call e-filing platform for upper tribunal court judicial review applications. And you have to make sure that you tell the court exactly what you are seeking the court to do for you in terms of remedy. And the most important is that, please make sure that you follow the process as we have pointed out. The implication will be that Home Office, after you have sent your application to court for review with the grounds, may review your grounds and come back and tell you that don't go further, we have conceded. And they give you a consent form, which court will approve and becomes an order. Or it will continue and the court will have to make the final decision. In that case, if you succeed in court, you are okay. The decision will be reversed. If you do not succeed in court, the decision will continue. However, if you don't succeed, you have to pay Home Office cost fees or legal fees. If you succeed, Home Office will pay your legal fees. This is what the conversation has been about. In any case, remember that whether you will succeed or not succeed, it's always good to seek judicial review.
Well, my producer really wants to draw the curtains down because we've gone a little over our time. We haven't overstayed our welcome because I know definitely you guys are there and you want us to continue for as long as there is something to learn. Thank you very much, Large Asma, for your time. Thank you very much, BWF Solicitors, for your support and the opportunity. And thank you out there for staying with us. We have really enjoyed your company. And for that, we want to invite you to join us same time next week when we bring you another edition of the Community and the Law. On behalf of my producer, Professor Ade, Sheila Ankra, the admin person, and of course, Pan Mododi, the aesthetic man. And on behalf of BWF Solicitors, we say have a good evening.